Hi, I'm Jay with Personal Bar Prep, and this is Simplified, our video series where we simplify complicated subjects on the California bar exam. Today I want to simplify for you the Battle of the Forms. That's right, UCC 2207. Now, the problem with 2207, I think, is severalfold. Number one, its application. When do you use it? When does it arise? How do we spot it as an issue? Secondly, what does the rule even mean? Because it's a fairly complicated rule. Well, stick with me and I'm going to simplify it for you now. First of all, because it's a UCC provision, it can only apply in a contract for the sale of goods. So we're always concerned, first of all, with jurisdiction in the contracts question. If you have the sale of goods, you need to be on the lookout for UCC 2207 Battle of the Forms. The next question is, when do you know to raise it as an issue in a sale of goods contract? And the clue is in the term Battle of the Forms. There must be competing forms. Now, what forms are we talking about? We're talking about a written offer and a written acceptance. Where you have such a beast, you then likely have a 2207 problem. And where 2207 becomes an issue is where the offer and acceptance do not mirror each other, where the acceptance has different or new terms than the offer had. Now we have a 2207 problem. And the question is, how do we resolve it? Well, the first thing we need to know is, are the parties merchants? If both parties are merchants, then we apply the following rules. If we don't have two merchants, then the rule is very simple. We have a contract on the terms of the offer, and the additional or new terms are merely suggestions, but we have a contract. That's if there are no merchants. That's a simple solution. But what about if 2207 problem arises and we have two merchants? Now we have to do some thinking. The first thing we need to know is, are the terms in the acceptance new terms from the offer, or do they contradict the offer? Or are they different, in other words? And the reason that matters is because the rules are different. So where the offer and acceptance differ because the acceptance has new terms from the offer, then what we do is we look to see whether or not the offeror objects to the new terms, or if the offer was a take it or leave it, otherwise an ironclad offer, or where the new terms will be material. So the rule is this: where the offer and the acceptance differ, and they're both in writing, and it's between two merchants, and the difference is that the acceptance has a new term from the offer, we have a contract. The only issue is whether that new term becomes part of the contract. If it is rejected by the offeror within 10 days, it's not in the contract. If it has been an ironclad offer, meaning take it or leave it, it is not in the contract. And finally, if it materially alters the contract, the new term will not be in the contract, and we have a contract between the offeror and the offeree on the terms of the original offer. That's how 2207 Battle of the Forms applies, where you have a new term in the acceptance. But what about where you have a contradictory term? For example, the offer says, I will sell you tires at my selection, and the acceptance says, I'll buy your tires at my selection. Now we have competing issues, competing terms here. What do we do? Well, the rule is pretty straightforward. All we do is we knock them both out. So those two contradictory terms, they're gone. They're not part of the contract. And we use gap fillers to figure out what to put in its place. Now, the UCC is replete with gap fillers. There are terms in the UCC that says if this term is missing, this is what will happen. That's a good way to fill in the gap. Another way to fill in the gap is to see how the parties have conducted themselves. So how have they acted during the term of this contract? Have they acted in such a way that we can fill in the term by their conduct? And then we can also look at custom and usage in the industry. And we fill in the knocked out term with the custom and usage of the industry. So let me give you an example. Years ago, the State Bar gave an essay in which the one party, a buyer, made an inquiry to a seller regarding the sale of tires. The seller responded with an offer, and the offer specifically said that the seller will select the tires and they will deliver 10,000 tires at the rate of 1,000 tires a month to be paid COD. The offeree, the person who accepted, responds with, "We'd love to buy those. We will make the selection," and they added an arbitration clause with no discussion whatsoever about the COD. So here we have a battle of the forms. The offer is silent about the arbitration. The acceptance includes the arbitration. There is a new term. The offer says that the seller will select the tires. The acceptance says the buyer will select the tires. Here we have contradictory terms. So what do? Well, first with the new terms, we ask the following. Number one, did the seller, the offeror, did they make an ironclad offer saying we're only going to sell under these terms and no other? And the answer is no, that did not happen. Second, we ask, do they object to it within 10 days after they received notice or after they received the acceptance? And the answer is no, that did not happen. The only other issue then is whether the addition of an arbitration clause is a material change to the contract. And if the answer to that is yes, it will be out. If the answer to that is no, then the arbitration clause becomes part of the contract. And the good news about an arbitration clause is there's a split of authority. Some jurisdictions say that an arbitration clause is material because one would likely want to negotiate that and would be surprised by its presence in the contract if it wasn't negotiated. Other jurisdictions say that they are ubiquitous, that they are so common in commercial transactions that they do not materially alter anything. Make one argument or the other and come to a conclusion. If you prefer the argument that it is not material, explain why it's not material as I just did, and then conclude we have a contract and that contract includes an arbitration clause. Now, what about the selection of tires? On the one hand, the seller says they're going to select them. And on the other hand over here, the buyer says, no, we're going to accept them. Those are contradictory terms, so what do? We just knock them out. We pretend they're not even there. And we have a contract, but that term is missing. So now we have to figure out who gets to select the tires. And it turns out that the UCC has a provision that says where a contract is silent as to who gets to select the goods to be purchased, it is the buyer's decision. And so the UCC gap filler in this case fills in the gap by saying the buyer gets to select the tires. But if you didn't know that, UCC provision, you would also see that the first two shipments were based upon the buyer's selection of tires. And therefore, the conduct of the parties seems to suggest that the buyer gets to select the tires. And that's what you need to know about 2207 Battle of the Forms. So let's recap. One must be the sale of goods. There must be a written offer and a written acceptance, and the terms do not match. Where that is between parties that are not merchants, we have a contract, the old terms, the offers terms control, and the terms in the acceptance are merely a suggestion. However, if it's between merchants, we still have a contract, but then we need to ask, is the term an additional term, or is it a different or contradictory term? If it's an additional term, it becomes part of the contract, unless it's an ironclad offer, meaning take it or leave it as is, or it's objected to within 10 days, or it's a material alteration. If it is a contradictory term, then we just knock out the contradictory terms, fill it in with UCC gap fillers, and move on our way. We're now done with offer and acceptance, and then the next thing you're going to have to tackle in that essay is whether or not there's any consideration, and then terms of the contract, etc. On the bar exam, this comes up kind of surreptitiously. And so you got to be careful. You got to look for these things again. Sale of goods, a written offer, a written acceptance that do not agree. Now you have a 2207 problem. I know it was tough in law school. Think about it. Take a look at some essays. You'll see by practice it's not that hard. If you enjoyed this video, like it or share it with your friends. And if you enjoyed the video, you're going to love our course. I'm Jay with Personal Bar Prep. Thank you very much.